आदाब नाज़रीन, आप देख रहे हैं गुलिस्तान न्यूज़ उर्दू खबरनामा लेकर। मैं आपका मेज़बान गौहर कुछी आपकी खिदमत में हाजिर। तफसीलात से पहले नजर डालते हैं सुर्खियों पर। और अब पेश खबरों की तफसील। सबसे पहले बात है 370 की। आज 10वें रोज भी सुप्रीम कोर्ट के अंदर दफा 370 मामले पर समाअत जारी है। सुप्रीम कोर्ट में जम्मू कश्मीर से मुतल्लिक आर्टिकल 370 की मनसूखी को चैलेंज करने वाली अर्जियों पर यौमिया बुनियाद पर समाअत जारी है और आज 10वें रोज समाअत जारी है। चीफ जस्टिस जीवाई चंद्रचूड़ की सरबराही में 5 जजों की आईनी बेंच इस मामले की समाअत कर रही है। जम्मू कश्मीर के वकला की जानिब से दलाइल मुकम्मल कर लिए गए हैं और अब सरकार की जानिब से जवाब दिया जा रहा है।
In the case of general run of reorganization of states or imposition of President's rule, the scheme and architecture of Article 356, which provides in regard to the sustenance of the fabric of the nation, will not be narrowed or compressed. The interim argument demanding course correction or linearly tailored and need not be touchstone for ex ante tinkering in the undefinable state necessity potential of Part 18 of the Constitution. All instruments in aid of discharge of duty under Article 355, including the preamble to the Constitution, will be comprehended in the plenary power of Parliament to engage in the reorganization scheme under Article 3. The plenary power to act under Article 3 is available even during rule under Article 356. Long-standing or similar measures in regard to reorganization are not precluded. The availability of power is distinct from any due process. A. Neither asymmetrical federalism nor any other federal features have been infringed. We'll try to make good all these arguments. No rights in relation to representative democracy have been taken away. Reorganization of states includes temporary or other rearrangement of rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measure of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace and justice have no inherent justice right to continue to exist, to right to exist or to continue. However, it is submitted that all measures taken are within the due processes granted and to be pressed into service to act in exceptional circumstances. All steps taken under so and so are within the standard set of provisions issued during President's rule and nothing arbitrarily designed has been provided for. All arguments and fraud and power are therefore misconceived. That's a broad summary of my submission. Just before the solicitor takes over, as part of the paragraph 7B, the last few sentences, I looked into all the presidential proclamations, running into 120 of them, and particularly in regard to Jammu Kashmir. The suspension of provisions of Article 3, the two provisos, and various other provisions of the Constitution of India, or in terms of a convention that the presidential proclamation follows. So no deviation is taken place as far as this particular proclamation is concerned. So suggest therefore either a fraud on the constitution is completely misconceived. I'll try to make good arguments referring to the documents. So I just want to play this summary to show that the due process has been followed. There is no deviation from due processes. All fall within the legitimate aims and objects of what the two orders sought to achieve. And the Reorganization Act also falls within the.
Thank you. Thank you very much, Mr. Attorney General. Yes, Mr. Sul.
Good. Great piece, Your Lordship. But as indicated by the petitioners, Lords, your Lordships would be taking a historical decision, Lord, in more than one ways. But first, this is for the first time, Lords, after 75 years, that your Lordships would be considering that the privileges with which the residents of Jammu and Kashmir have been deprived of till date, have been conferred. And I make this submission good, that so far, Article 370 function as a detriment between the welfare scheme flowing from the center, the constitutional right flowing from the center, and the residents of Jammu and Kashmir. But second thing, but because of this confusion, whether it is temporary or permanent, there was a kind of a psychological duality which was in the minds of one particular region of our country, though since inception of the constitution, it became part and parcel of inalienable and integral part of India, but there remained a psychological duality, whether induced or otherwise. That, my Lord, your Lordships would end. Judgment going either way, my Lord, that position would end. And third, my Lords,
Mr. Solicitor, the first one, can you just in a sentence again formulate it? I somehow missed the first one.
Yes. Lord, your Lordships would find at the end
I
of.
don't want to interrupt my learned friend, Malat, but the new volume has been added. 2 new volumes have been added, which were not there before, 2 days ago. I don't know, Malat. I may be wrong. I have no objection, Malat, but I just want to point that out.
It was added with the permission of the court before 6 days.
It was added, that's all I'm saying, Malat. The written submissions are new. I'll not object to any of that because I don't believe in objecting to materials which are relevant for the court.
No,
But since the court told me.
permitted. We mentioned your Lordship.
I'm not disputing, you may have mentioned. I'm just saying, Malat. I have still no objection, Malat.
Volume 3 are your submissions, Mr. Solicitor?
What, your Lordship, my Lord, the Chief Justice would recall, Lord, what we have done is my submission, the submissions of the learned attorney, and my Lord, all our submissions are placed in one volume. Our submissions, my Lord, were new and detailed after, my Lord, hearing them. And thereafter, my Lord, in a chronological order and with continuing pagination, they form part of volume number.
On Monday, when the solicitor mentioned in the morning, you informed us that the list of dates which has been filed by Mr. Sibal.
Yes, that is incorporated.
You are adopting the same list of dates, but where you are adding something,
Yes.
you are putting it all together, so we don't have to flip between list of dates.
Written submissions are all new here.
Lord, this
Are
could have
all
been
new.
objected
I'm
on
not
that
disputing.
day,
I
Lord.
still am not disputing.
I believe.
I still will not dispute, and I'm just saying, Malat.
Then let's start, my Lord, because
I'm only saying, Malat, I was not allowed, that's all. All these are all new, but I don't mind, Malat, we'll answer.
What we had, when he mentioned on Monday morning, I think we asked him whether your notice has been given to everybody, and solicitor said yes. At that stage, I told the solicitor, instead of having 5 different list of dates, work on the list of dates which Mr. Sibal has submitted. I'd also mentioned it in the course of the hearing.
That's right, sir.
And in that list of dates, add what you are adding separately so that we know what has been the addition by the Union of India.
not only that.
All of us have one master list of dates that becomes much easier.
I don't know.
It would have been better if this objection would have been raised. Because let's not,
Sorry.
my lord, people are watching, let's not be, my lord, school children like objections, my lord. It was given on that very day at night.
No, it's because the
Not
court has-
Apart from that,
not
please
informed.
hold your tongue.
Document is created on 24th August, which is today. The PDF says it's created 24 August. So I don't know how it could have been.
Mr. Prasanna,
Anyway, Malad, I think we should go on with the hearing. I'm not objecting.
No, let's say.
You object and thereafter you are saying I am not objecting.
Because I was told that I should not be able to add anything. I had only put some, just 5 pages.
Whatever is,
Assuming that
Your submission also, it would have resulted in many more people.
That's why, Malad, I didn't press it.
I don't think we should go on this.
But even that has been taken note of.
That's all I'm saying.
Mr. Gopal Shankar Narayan was here from day one. He could have told us, but my lord, I must make a positive statement. Before we mention before your lordships, the previous night, this was placed on record with a service to all. They were aware and my lord, they knew that this is the master list of dates which all of us on this side will rely upon.
Your Lordship, may I clarify? One second. Mr. Solicitor, on your master list of dates, I hope you have maintained the integrity of the original list of dates.
Yes.
Where you want to add something that you have indicated to us in a separate note or separate color or track change.
What I have done, my lord, I believe at the outset that it seems my list of date contains something because this first objection appears to be the best point now after my lord, this list of dates. But leave it at
No, Mr. Solicitor, the reason why we ask you is, when one sits down to dictate the judgment, I hope in the list of dates, we will know what is Mr. Sibal's part and what is your part. So long as that is there, it's no difficulty for
Come
us.
to page 1 of my list of dates.
So long as it is there, we accept your word for it, but so long as your juniors have prepared it in that way, there's no difficulty.
Mr. Sib, only a minute. Mr. Sibal's submission are incorporated in that general common list of dates in italics in blue color, saying KS means that's the list of dates of Mr. Sibal.
And whatever you wanted to add, you've added in a separate font or whatever, then there's no difficulty.
Nobody has any issue with the list of dates. It's just that they are filing something, they should tell everybody. What has been done today is there are 107-page list of dates which is filed.
Mr. Prasanna knows everything was served. You please tell you, this is what a nodal council is supposed to do.
Yes.
So,
I'm
please a moment. The learned solicitor's written submission, apart from the list of dates, has somehow ballooned from 18 pages to 139 pages. And a lot of it in very fine print. Now, I mean,
I'll put it a para.
Airdrop 3 minutes ago, 5 minutes ago, I got it on airdrop.
Huh?
So
But from Mr. Prasanna, not by me.
if you're nobody, when Mr. Sibal says he has no objection, there's.
But from your nodal council, he gave you date.
Yes, may I clarify?
We can.
Mr. Prasanna is trying to say something for last 5 minutes.
Yeah, Mr. Prasanna.
Yes.
Just 1 second. Let's have a word from the young junior
We
here.
were certainly served last week, Your Lordship. I had not been informed that it had been allowed by the court, which is why I could not circulate it forward. So that was.
So
It was uploaded on Sunday night. The lordships can check up now. Everything, my lord, is possible to be ascertained and verified.
So say that it was emailed to him on Sunday night with a copy to Mr. Prasanna.
Yes, my lord.
Yes, that's correct. That's
In fact,
correct.
we should-
It was
I
not
don't want to
circulated
find
because it
fault
had
with
not
it.
been allowed by the
Say
court. That
it
is
has
not something
come.
that I had been informed that it had been allowed by the court. That was where the case is.
My lord, my first point, my lord, why your lordships, my lord, judgment is going to be a historical judgment is this. A, my lord, after going through, my lord, the facts which we will point out on this side, your lordships would be satisfied that large number of fundamental rights and other rights will be now conferred upon the residents of Jammu and Kashmir. And they would be fully at par with the rest of their brothers and sisters of this country.
Yes.
Lord, number two, Lord, because of, I'm sorry,
Yes.
because of the ongoing confusion, which according to us there was none, but because of the ongoing confusion whether this provision is temporary or it has become permanent, etc., there was a psychological duality amongst the minds of the residents of Jammu and Kashmir, and that was being taken disadvantage of by, I would say, my lord, interests not inimical to India. That would be settled once and for all, whichever way your lordship decides.
Yes.
Now, my lord, I'll take your lordship, my lord. I must, my lord, assure your lordship that yesterday we undertook an exercise that your lordships have been appraised with almost everything, my lord, on facts. But your lordships are specifically not appraised with many things. So, my lord, in my list of dates also, we have, my lord, marked which portions we would not trouble your lordships by reading. So kindly directly come to, my lord, in that common compilation, page 6, PDF page 6. But this is only for one reason, my lord, I am reading this part. My Lord Justice Gawai was pleased to put a question. There was a Praja Sabha constituted, your lordship would recall. And my lord's question was, what was the composition of the Praja Sabha? So that is what is mentioned. Your lordship would find the second date, my lord, on this page is 20.
Just only one thing, Mr. Agarwal. I'm not asking the solicitor this. In the list of dates, there is some dates which are marked by the light brown.
Yes.
One by green, one by blue, and
Please come to page
so
4.
is there a distinction for our
Please come
purpose
to
between
page
is there a like green, blue?
It's a legend. Page 4. Page 4 will be the answer.
We just want to see
Page 4.
when we have clarity, you know.
This is one of the color scheme which we have used.
All
History
right.
of Kashmir is this color.
All right.
Then British events, law and statements.
Agreed.
Then blue will be Indian constitutional history. Red with the process of integration, etc. This is the relevance of the color.
All right.
But your lordships need not, my lord, bother about that. My lord. Once
All right.
the flow I have kept chronologically. So therefore, colors might keep on changing depending upon the legend, but the flow will continue.
And where you say KS in italics, that is Mr. Sibal's original. Fair enough. Got it.
Sibal's submission. Therefore, your lordships may consider not keeping Mr. Sibal's submission side by side. It contains everything verbatim,
much easier.
as my lord produced before your lordships. That's all I wanted to show. Date 20th of April 1927. I'm not reading it, but this is Mr. Sibal's submission in his list of dates, and I have not missed, my lord, any date from his submission. It is in blue color and in italics. The next date is 22nd April 34. Maharaja Hari Singh enacted 1934 Constitution of Jammu and Kashmir. This law established a legislative assembly called Praja Sabha, which was to function under the supremacy of the Maharaja. Lord, answering my Lord Justice Gawai's question, the Praja Sabha was to have 75 members, of which 12 would be officials, 33 elected members, and 30 nominated members. Then, my lord, rest your lordships can consider skipping, my lord, and kindly come to, my lord, 7. Just, my lord, taking your lordships chronologically, your lordships have seen this provision as well. I am just, my lord, refreshing your lordship's memory without reading the provision. Lord, this is a part of Government of India Act 1935. Lord, why it has become long, the relevant parts are quoted for your Lordship's immediate reference. My Lords may not have to go through volume 1, PDF page so and so, but page numbers are also mentioned, my Lord, if your Lordship would like to go through. But please see, my Lord, at page 8, section 6 of Government of India Act 1935. Accession of Indian states. A state shall be deemed to have acceded to the Federation if His Majesty has signified his acceptance of an instrument of accession executed by the ruler thereof, whereby the ruler for himself, his heirs, and successors, Lord, declares so and so, so and so, so and so. Lord, the purpose of showing this is to, Lord, point out to your Lordships, and ultimately I'll assist your Lordship with that proposition and one or two judgments on this. The moment the accession is complete, the sovereignty gets lost. The sovereignty is subsumed with the bigger sovereign.
Yes, sir.
There is a Privy Council judgment and few other judgments also, Lord, which we'll, Lord, take a little later on. Lord, there is one trivia, Lord, I have just added it. It doesn't make any difference for either of us. But as, my Lord, we attribute the Indian Penal Code to Lord Macaulay, Lord, this entire exercise of 1935 Act was done, my Lord. He was the author virtually of this, my Lord, Sir Samuel Hoare. One of the unsung heroes, my Lord, in the history of Indian partition, but it was he who drafted this. It has no bearing on the main question. Then, my Lord, I have reproduced the...
Actually, Mr. Solicitor, you may also read section 5.
Yes.
Because what is the importance of accession? That section 5(1) gives us.
Yes, Lord. I wanted to read,
Just
but I thought your Lordships may have read. Lord,
No,
kindly come
but we
to,
need
Lord,
to highlight
section
that
5,
because
PDF page 7.
it shall be lawful. They just read that only
It
that.
shall be lawful for His Majesty, if an address in that behalf has been presented to him by each House of Parliament, and if the condition hereinafter mentioned is satisfied, to declare by proclamation that as from the date therein appointed there shall be united in a federation under the crown by the name of the Federation of India. A. The provinces hereinafter called governors' provinces, which were under the direct British sovereignty or suzerainty, as the case may be, were functioning through the Governor General. Then B. The Indian states which have acceded or may thereafter accede to the Federation, and in the Federation so established, there shall be included the provinces hereinafter called Chief Commissioners' provinces, not the smaller regions which eventually...
The consequence of an accession under the Government of India Act was that then the acceding, they would be united in a federation.
In the federation.
The key words really in 5 are united in a federation.
In a federation. So, my Lord, that is the first stage of losing sovereignty. The moment you sign accession and it is accepted.
But you'll have to at some stage deal with the argument which they have urged that sovereignty itself has an external component and an internal component. External component was lost, internal sovereignty still remained. That's the
argument, my Lord. We are conscious of that. And, my Lord, I'll also bear in mind your Lordship's very, very pertinent observation that ends may not justify the means. I'll also show to your Lordships the means adopted strictly within the constitutional parameters and as per various judgments of your Lordship. But that's, my Lord, after, my Lord, the factual chronology. Thereafter, your Lordships, my Lord, kindly come to page 9, 1939. But this is also crucial. The Indian National Congress's formal stance was that the princely state must join independent India on the same terms and with the same autonomy as the provinces of British India, and with their people granted responsible government. As a result, it attempted to insist on the incorporation of the princely states also into India in its negotiations with the British. So we were, Lord, British India, also, our leaders were already negotiating that princely states should also come at par with the provinces, British provinces, which were already under the suzerainty or sovereignty, as the case may be, of the British. Then, my lord, 7th September 1939, Jammu and Kashmir Constitution Act 1939 was issued by Raja Hari Singh. It established a council with a prime minister. Lord, why, my lord, I'm reading this, my lord, I'll just paraphrase this argument. Lord, why I say this? Lord, substantial arguments, my lord, were made that there were no constitutions. Jammu and Kashmir had a special place in the geographical British India because that was the only part which had its own constitution in 39. But that is factually incorrect. There were 62 states which had their own constitutions. Whether they are named as constitution or any instrument of governance, internal governance. I'm just trying to show that the argument that Jammu and Kashmir had a special status from the beginning, which continued till date, is factually wrong. The foundation is wrong. And 286 states were in the process of framing that constitution during this period of late 40s, late 30s, 39 onwards. As a matter of fact, but eminent councils of the day, those days, were, my lord, engaged to help the princely states to draw their constitutions. I'm not going into that detail, that's not relevant, but one of the, my lord, when we researched this, Alladi Krishnaswamy Iyer, who was considered to be one of the top ranking councils, was engaged. His fees were not found to be, the problem was there at that time also. By one state called Rewa in present Uttar Pradesh, I'm sorry, Madhya Pradesh. And therefore, my lord, he was requested not to continue because it was found to be too exorbitant. My lord, please see, my lord, from where do I get this? My lord, PDF volume 16, document volume 16, I'm sorry, document volume 16, PDF page 574.
Document volume
16.
Lord, this is a research paper by a very eminent professor of Yale. He has, my lord, done at 584 directly, my lord, because this is history. I may not, my lord, trouble your lordships beyond a point, but 584. The running page would be 10514. But as a matter of fact, some of them made their constitution and thereafter immediately signed the accession also. And I'll also show to your lordships from this chronology that the draft accession agreement was common to all. Everybody has signed the same draft. I'll come to that. Please, my lord, see the second line. However, at page 584, my lord Justice Khanna and my lord Justice.
Yes, I got.
Yes, my lord Justice Call has that. However, the inauguration of Shahpura Constitution did not prevent the prince from signing the next day the instrument of accession to the dominion of India in 3 areas of defense, external affairs, and communications, as many other princely states did at the same time. Lord, next para, kindly come, Lord, some 5th or 6th line from the top of the unnumbered second para, Manipur. Your lordship would find Manipur. Does your lordship get Manipur? Manipur in the northeast adopted a constitution which on 26th of July 1947 provided for fundamental rights and separation of powers, and recognize the Maharaja as its constitutional head. Maharaja of Patna declared the setting up of a representative constitution making body on 24th October 1947. Just as at the moment when the first draft of Indian constitution was ready, that same month, M.R. Jaikar, until the previous May, a member of the Constituent Assembly, advised Gwalior State Constitutional Reforms Committee not to depart in their proposed constitution from the model now in vogue, for instance, at Mysore. This pattern of general steps towards constitutions based on principle of representative government was repeated in numerous other princely states. These included Ond, Banswara, Bauni, Baria, Baroda, Barwani, Banaras, etc., my lord. The list goes on and on and on. I'm not reading it because the names are not relevant. And this is whole length and breadth of the country. They were making either having their constitution or making their constitution. My lord, why? I just, my lord, we were just, my lord, examining why these three subjects are kept, my lord, even by them to themselves, my lord, namely defense, communication, and, my lord, foreign affairs. The reason was, answer. But there is a small princely state. It can't have its own army. Communication means the British had laid postal services and Britishers have also laid railway lines. So that communication was crucial, and every state can't have their own communication system for intra-princely state communication. And foreign affairs, obviously, they would like the greater power to control. That was basically the idea. Thereafter, as I go on, the lordships would be satisfied that ultimately everything started getting subsumed